Welcome to this week's episode of Coffee and Policy Chats. I am your host, Ashley C. As always, I love talking about policy. I don't work for the government or any news work. I'm not a journalist. I'm just someone who has studied a lot of public policy and has learned to break it down in a way to make it more approachable so that you can be aware of those public policies that are floating around, pieces of legislation that affect policy, and make the best decision that is right for you. So this week, we're actually going to be talking about the recent election law reform from Congress. If you recall, it was part of the appropriations bill that is on its way currently to being signed by the president. But by the time this episode airs, it probably more than likely will have been signed in within the new year, the first couple of weeks of the new year. But before we get to that, we have some quick bites that should be on your radar. And these are just, in the fun spirit of the new year, there's always new laws that come out. And a couple of the ones that hit my radar were from California and Illinois. And so these were just things that, had popped up in my feed at one point. And I thought, oh, let me look into that. That's kind of interesting. So in California, AB 2223 takes effect. And that not only protects someone who seeks abortion care in the state from prosecution, even if it was self-induced or outside of a medical facility. It also abolishes the requirement that coroners investigate all stillbirths and protects those who help someone seek out abortion care from criminal or civil liability. Especially important since some neighboring states are considering banning abortion or have already banned abortion. And so as people are trying to come to more reproductive rights friendly states, that is exceedingly important. And also AB 1949, which makes it illegal to deny somebody bereavement leave. So if you've been working for your employer for more than a month, that's 30 days. It actually specifies 30 days. And your employer has 5 or more employees, they have to give you bereavement leave. Bereavement leave is important. It's up to the employer whether or not you can get paid during that time. Most employers have it unpaid. And then SB 731, which is a step in criminal justice reform, actually. And hopefully this will stop recidivism. Basically, the law permanently and electronically seals most felony convictions. That's an important word, most, not all. The caveat to getting your conviction sealed is that you have to fully complete your sentence, and that includes any time that you were ordered to be on probation, and you have to have so many years without subsequent arrest or rearrest, and you can apply to have that done. It would also apply to people who were charged with a felony and served time in state prison and have a record of an arrest but never got a conviction. So if you were arrested but not convicted, it would seal that record as well. I know that there's some people who are like, oh no, we shouldn't be sealing records. There are caveats. People who want to apply for jobs in certain industries can still have those records viewed. Like if you're applying for a school district, hospital job, public office, law enforcement job, they can still see those records. And then sex offenders are excluded from this legislation, so their records would never be sealed. They are always going to be on the record as being a sex offender. And then this one's kind of interesting because, I was reading an article recently about how in some families there are grandparents and great-grandparents who are passing away, and they have fur coats, fur stoles, because back in like the 50s and 60s and even the 20s and 30s, that was a style. It was a sign of wealth if you could afford some real genuine fur items. Well, in California, they are the first state in the nation now to ban the sale and manufacture of new fur products. It's under AB 44. It doesn't impact anything that is being created or sold for religious or tribal purposes, but, residents of the state cannot make or sell clothing, shoes, handbags, any of that kind of stuff for fashion purposes. And then for those of you in California who may have a relative who struggles with severe mental illness, SB 1338 goes into effect. And this one is something that I think a lot of families that struggle with severe mental illness probably are in support of. Basically, it lets family members, first responders, and others to ask a judge to draw up a treatment plan for someone who's been diagnosed with certain psychiatric disorders. These have to be severe disorders, which includes schizophrenia. Those who refuse can be placed under a conservatorship in order to comply. So like if they have a treatment plan and they're refusing to comply with their treatment plan, which sometimes is the case with people with severe mental illness, they start to feel great, so they stop complying with their meds or whatever else the treatment plan is. And then it's hard to get them back to being stable. So the new law would basically allow family members to seek out the judge to draw that up. The step would be the judge has to draw that up based off of input from medical professionals. And if the person chooses to not comply, then they would have a court order. And it's for up to a year. And it can be extended to a second year. The plans can include not just medication. That's really important, but it could also include therapy services or housing. And it is much easier to treat somebody when they are getting everything they need, including housing. It's going to be under this thing called Care Court. So families, clinicians, first responders, they'll be able to refer individuals to the court. And Care Court is going to be implemented statewide, but it has a phased-in approach. So the first counties in California to get this program and this particular court system, judiciary system mechanism is going to be Glenn County, Orange County, Riverside County, San Diego County, Stanislaus County, Tuolumne County, and San Francisco. So that is actually a really good example of how policy is implemented. So policy can be anything from legislation that results in a law or legislation that results in programs. And so then programs have to be administered by somebody. And programs make up a large chunk of what we see in policy implementation. So this particular program, CARES Court, is a program within the California judicial system. So it sets aside, like, this is how it has to happen. These are the procedures for the program. And this is who is administering the program, which would be the California Department of Justice would be the ones administering this program. So this is a very good example of how bureaucracies, which are those departments that have oftentimes many lifelong civil servants working for them, and legislation work together. So this is a very good example of public policy actually at work. And so that was one of the reasons why I had to bring that up. And then out of Illinois, they have introduced the Safety Act, which was going into effect. It has a number of criminal justice reforms, including the elimination of cash bail. That has actually been considered pretty controversial in states that have implemented the elimination of cash bail. There are arguments for and against. Some of the arguments against is basically that you're letting somebody dangerous out on the street. Some of the arguments for is that the current cash bail system penalizes the poor because oftentimes they don't have collateral or the ability to meet those bail amounts. And in California, they at least look at it from the offender level. So obviously, if you're like a felon murder charge, you're not going to get bail. But if you got picked up for maybe a drug related charge like possession, you may get bail, or you may not get bail, and you may be released. So they're doing that in Illinois as well. And then they also passed their version of the Crown Act, which was modeled after California's Crown Act, which prohibits discrimination based off of traits that are closely identified with race, such as natural hair textures or protective styles. And then this one is actually like really cool from a women's health perspective. So they have two of them, HB 5254 and HB 4271. And HB in Illinois is House Bill. And that basically, HB 5254 mandates coverage by health insurance plans who want to operate in the state for medically necessary hormonal treatment in women who have undergone medical procedures that has forced menopause. So for example, if you had a complete hysterectomy, which means they take out your ovaries, you're going to be forced into menopause. And so hormonal treatment may be recommended to help prevent things like osteoporosis or other complications associated with that induced menopause. And then the second one is HB 4271, and that requires the state private insurer. So if you want to operate in Illinois, you have to cover breast reduction surgery where it's medically necessary. So if a patient is eligible because, for example, their breasts are too heavy, and that can be a problem with large breasts, and it causes backaches, then it could be covered by insurance. The patient no longer has to worry about paying for that out of pocket. And then a number of states, including those two, but a number of states around the country have introduced other laws around workers' rights, including which includes some strengthening of employee protections around unionization, which we've seen a lot of in the recent day, or like the last 2 years, actually, I think, and also raising minimum wage. And then this one's a piece of news that also shows the intersection of policy and program administration. So the Department of Transportation, the U.S. Department of Transportation, has announced via their Twitter feed that they are opening an investigation into the budget airline carrier Southwest. This was announced just yesterday as of this recording, so that was 12/26, so the day after Christmas. And this was because they had massive cancellations of flights due to the Christmas travel holiday weekend. Other carriers did cancel their flights as well, but Southwest had a lot more. In fact, Southwest had 70% of their Monday flights canceled and 60% of their flights for Tuesday canceled. Now, Southwest did release a press statement. They stated that it was because of the extreme winter weather much of the country is experiencing that they did cancel them. And they're anticipating that there may be further delays just because of the backup in travel related to this. So this is another good example of a bureaucracy who is doing one aspect of their job to enforce policy. And this actually comes because the U.S. Department of Transportation also oversees the FAA, which governs our flights here in the United States, our airlines. And if you go to the U.S. Department of Transportation website, you can actually submit complaints about canceled flights, delayed flights, other things that may violate policies. And if they get enough, they will investigate everyone, but it takes time. In this case, I'm pretty sure they got quite a few complaints because of how this was handled by Southwest. People were stranded at the airport. That basically was a call to action for them. So they announced this investigation rather quickly. So that is another really good example of oversight provided by a bureaucracy who is tasked by legislation to do a certain job. So that is it for our quick bites today. That is our digestible pieces. I am now excited to move on to the main policy topic, which is election reform, specifically electoral count reform. So we're going to be looking at the Electoral Count Act of 1887 and the more recently passed reform to that act, and what it means. So I will be, if you're watching this on YouTube, you get the pleasure of seeing me scroll through the actual documentation on it. I might actually look up the bill while you guys are here and show you the pieces of a bill, but I don't know. It depends on if we have time, if there's value to it. So if you've not heard of it, well, you probably have by now. We have this antiquated, very, very antiquated law that was first passed in 1887 called the Electoral Count Act of 1887. I know, creative name, right? Very creative name. And then it was signed into law by President Grover Cleveland on February 3rd, 1887, which is why it's called the Electoral Count Act of 1887. There's no imagination with lawmakers. Anyway, it was later codified into Title III of the U.S. Code in 1948. So it's important to know why this act was passed originally. And this was because it was 10 years. Like, picture this. And I feel like Sophia from Golden Girls. Picture it, Sicily. No, we're not in Sicily. It's the United States. It's basically picture it in Washington, D.C. back in 1876. And the election is over, but it is highly contested and disputed because of the results. And it took several states time to submit the results. They also submitted competing slates of electors. Electors are those people who cast the votes in the Electoral College. So Congress became deadlocked. Like, they just could not figure out who the winner should be. They could not call the election, and it took them weeks to resolve the matter. So this was a lot of time off of their legislative agenda, that they couldn't get anything else done because we didn't have a president. So they resolved it finally after many weeks, and we got a president. And then in 1880 and 1884, those elections were both very close, almost too close to call. And because of that, now Congress did not get deadlocked again. That was the good thing. But Congress decided that they had to do something about it. Like, they just had to do something about it. In the U.S. Constitution, there is leeway for Congress to decide how to do the Electoral College votes, how to count them. And then the 12th Amendment of the U.S. Constitution also specifies the VP's role as the president of the Senate, opening the electoral certificates. So they thought, well, this has happened again. This might happen again because these are really close. And this is a time in America where we tended to have a lot of really close elections like we do now, but the counting and election process was very slow because they didn't have voting machines. You had to physically go in and vote and hope they didn't stuff the ballot boxes in some cases. There's interesting stories out of Chicago and New York City about stuffed ballot boxes. And I apologize if I'm looking away a lot. It's because I have notes and I want to be very factual as I go through this. So basically, their intent in drafting and passing this Electoral Count Act of 1887 was to add the procedure for counting electoral votes following a presidential election that were outlined in the U.S. Constitution and minimize congressional involvement in disputes. So Congress is like, we got better things to do. Peace. Y'all need to figure this out, so we'll tell you how to do it. That's literally what this was about, because they're like, we can't do anything if we're deadlocked trying to decide who the bloody president is. So then it created procedures and deadlines. Basically, it said, here's how you do this, and here's the deadline for you, state, to follow in resolving those disputes, certifying your results, and getting them over to us in Congress. They were like, we're the boss. Y'all got deadlines. Do it now. Right? So it also told the states that if they followed safe harbor standards, which meaning they were following the appropriate conduct, and the state's governor properly submitted one set of electoral votes, only one, not two, not three, just one. The act stated that this final determination shall govern. So basically, whatever the governor sent over of the state and said, this is our certified count, these are our certified electoral votes, this is what is going to take precedence. And the act stated that, the final determination shall govern. So it also stated, this one's important, it added to U.S. code. So if you're one of those people that really likes laws, especially federal laws, or you're in law school, you might know this. Or if you plan on being an ADA, you might have heard of this. Basically, it established under 18 U.S. Code 1001, Chapter 47, Fraud and False Statements, that, quote, any false writing or document in the implementation of this procedure is a felony punishable by 5 years imprisonment. So if you submit false documents like what we kind of saw in the last election, well, we did see it actually. I don't know why I'm mixing words. We did see that. You can be imprisoned because you're making a false statement. You're knowingly making a false statement. You're not acting in good faith. You are knowingly lying. And this is something that is very consequential. So that's basically what that act was. And now we're going to fast forward over 100 years. Now, this was passed in 1887, signed into law. We wrote a code about it in 1948. But the actual legislation was passed in 1887. Fast forward. Year 2000, Bush v. Gore. And there were some highly contested votes in Florida. So if you think about it, for 100 years, over 100 years, this law was never tested. So if you're saying, well, why do we have such an antiquated code on our books? Why didn't we have some like reformation before 2022? The truth is, nobody thought of it because it was an untested code. Nobody had tested it. Nobody had said we need to test this law, this piece of legislation, to see how it works. Now, in 2000, though, we had Bush v. Gore. So that was the 2000 presidential election. There was some contested votes in the state of Florida, and a lawsuit was brought. So this was actually the first court case to ever test this piece of legislation. More than 100 years later. That's think about it. It's a little crazy, right? So the case was brought because basically of those contested votes. And so there was an aggrieved perception under the federal law that something had gone awry with the count. And so the courts were asked to step in and decide the count. And the reason why I say this is important is because this particular statute, this law, was used by the court. Specifically, the timing provision of the act was a factor in the court's decision. So in the Supreme Court's decision, that was one of the factors that they had decided. And ultimately, they gave the votes to Bush, and President Bush became our president. President George W. Bush, the younger, not George H.W. Bush. So that was the first litmus test of that particular piece of legislation over 100 years later. And then if we look at the Constitution, and this is something, again, that nobody thought they would have to think about. So there was never any legislation or anything that clarified. The 12th Amendment of the U.S. Constitution specifies that the VP, acting in the role as the president of the Senate, opens all the electoral certificates coming from the states. And the original 1887 Act clarified that the VP's role was limited and that both houses could overrule the vice president's decision to include or exclude votes, even if they disagreed. So they could disagree. So if the House and Senate both disagreed, then the governor's certification was what broke the tie, not the vice president. So the vice president makes no decisions really about ties. If the vice president decided to include or exclude votes, Congress, both houses had to agree. If they couldn't, then the governor's certification is what broke the tie. So that was where the votes went. So this is where things get sticky. And this was actually one of the reasons why we had the January 6, 2021 insurrection. So basically after the 2020 election, in which former President Trump lost the election, the Electoral College votes, He and his attorneys decided to file multiple court cases in key states to challenge the election results. So all of those court cases did not go in his favor. He was ruled against. It was ruled that those votes were valid votes, and they could be counted. So some of his attorneys, in fact, John Eastman, which you've probably heard his name a lot in association with this, and as the special counsel is investigating and Congress finished their investigation, his name kept coming up a lot, thought that under the 12th Amendment that the vice president could then throw out the results of certain states. And then certain members of Congress in the Republican Party did try to contest the state certified election results. So it was felt that the law was written in a way that would allow them to do that, based off of this attorney's analysis of the law. Because it was written in a way that for some modern people, it seems very vague. And I'm thinking what was specifically latched onto was the provision that where it says that the VP's decision to include or exclude votes could be overruled. I'm thinking that the thought process behind challenging this with the 12th Amendment and trying to get then Vice President Pence to throw out certain votes was because of this thing. So the thought was, he can just exclude votes if we have enough Republican members of Congress to contest the votes in both houses, then, those votes will get thrown out. Most scholars do not agree that that is the case, that you can do that. But there is a perception that it could give you the wrong impression the way it was written. So that is where we had like a gap in the language and the legislation. And again, because nobody had ever thought to reform this, it'd been so long since it'd been challenged. We'd never had an insurrection like this around an election. It was just one of those things that people did not think that they needed to challenge, right? So based off of all the information we received, as the committee that was investigating the insurrection was doing their job, all the firsthand accounts that we received, Senator Susan Collins of Maine wrote and introduced this bill, which is called S-4573, in October of 2022 to the Senate. And it was entitled the Electoral Count Reform and Presidential Transition Improvement Act of 2022. So the bill's intent was to revise the process of casting and counting electoral votes in presidential elections. It also added provisions related to the transition of power between the president-elect and the outgoing president. And basically the intent was to make it clearer. Now we know that this bill was added to the Consolidated Appropriations Act, and it was passed as part of that on December 23rd, 2022. So it was in the Consolidated Appropriations Act 2023, that big omnibus bill, and it passed. And so now it will go into law. And if you look at the original bill on the Senate's, like the Senate bill, if you go to congress.gov, which I will link to, there's a lot of strike throughs, meaning that there were some edits to that done. There is a summary that says what was the original intent, then there's a lot of language, and then there's a lot of strike throughs. So that means it was gone through and those things were struck from that actual bill. So I am going to pull up the neat one pager that was on Suzanne Collins' page. She posted a PDF about what was actually in the electoral reform bill. So let me just pull that up for a second, and then we can look at it together. Let's pray that technology does me good today. All right. Hopefully y'all can see that. So I am going to be reading this as we go, and I will try my best to interpret it because this is my first time reading through the whole thing. I just noticed it was there. Let me take a sip of water because I've been talking an awful lot. All right. So the Electoral Count Reform Act of 2022, let me just move my mic. The ECRA for short would reform and modernize the outdated 1887 Electoral Count Act to ensure that the electoral votes tallied by Congress accurately reflected each state's public vote for president. It would replace ambiguous provisions of the 19th century law with clear procedures that maintain appropriate state and federal roles in selecting the president and vice president of the United States as set forth in the U.S. Constitution. Basically, Suzanne Collins was like, girl, you busted. So we're going to fix this. And she's one of the more moderate Republican senators. So I am actually not really surprised that she would bring forth this piece of legislation. I'm not going to say she goes against parties. She does not. But she is very moderate. So she's one of the more sensible ones. So key provisions include single conclusive slate of electors. So it, just like the original act, it says you can only have one slate of electors. You cannot have two. You cannot submit any more electors after a certain date. You only get one. You have a deadline. Make sure it's done. We're not making exceptions. We are trying to run a democracy here. You have to do your job. That's what it says. That's literally what I think it says. So it includes a number of important reforms aimed at ensuring that Congress can identify the single conclusive state of electors. And I'm going to emphasize that every time. Just one. It identifies officials to submit the slate. So it identifies each state's governor unless otherwise specified in the laws or constitution of the state in effect on election day. So when election day rolls around, if your state says it's not the governor that has to submit it, but it's the Secretary of State, then that is who would submit it. If it's not specified, it's the governor. That is literally where those come from. It can only come from two places: the governor or the Secretary of State, if your state says so, or I don't think many other states would use anybody else besides the Secretary of State to submit, but they could, but it has to be very clearly defined of who is submitting, and only one person can do it. Not one person, but one party can do it. Let's see. Unless otherwise specified in laws or constitution, in effect, the sitting of election day, as responsible for submitting the certificate of ascertainment. Ascertainment means basically that certification, identifying the state's electors. You're stating to your truest ability, you are not knowingly submitting false information, that these are the state's electors. You are certifying that these are the people that can cast the state's electoral college vote. Congress could not accept a slate submitted by a different official. This reform would address the potential for multiple state officials to send Congress competing slates. And then it provides for expedited judicial review. So it provides for expedited review, including a 3-judge panel with a direct appeal to the Supreme Court of certain claims related to a state's certificate. English, Ashley, English. Oh, I got tongue-tied there. To a state's certificate identifying its electors. I just realized that it did not change for you guys. Sorry. I'm sorry. Let's move that up so you guys can see that as well. This accelerated process is available only for aggrieved presidential candidates and allows for challenges made under existing federal law and the U.S. Constitution to be resolved more quickly. So basically, if another Bush v. Gore came up, there's an expedited process. So it kind of changes a little bit of the timing of things, because you know that it's going to go through the court system pretty fast, and that there needs to be 3 judges who all agree to render a verdict, so that way you don't have a tie, or you don't have one just interpreting the law by themselves in this case, because this is something that's way too important. And it makes sense. It makes sense. And then it modernizes rules for for counting electoral votes. It requires Congress to defer to slates of electors submitted by a state's executive pursuant to the judgments of state or federal courts. This one is basically Congress cannot say, no, we don't want this. You can't be like a representative or a senator who says, no, we don't want this. So we're going to dig in and contest it and try to make sure that the president who is not of our party or the president we don't like is not given the votes that they were entitled to. They have to defer to what the state says. So if the state says that this is our vote, like for example, in states where it's like you win the whole state based off of who got the majority of the popular vote, and so you get all those votes. Whoever the state says gets all their electoral college votes. Members of Congress cannot say, nope, we don't want that. We're going to stand up and say, no. What the state says is what they want is what the state says is what they want. It's the will of the people of that state. So then it also talks about the role of the vice president. It affirmatively states that the constitutional role of the vice president as the presiding officer of the joint meeting of Congress is solely ministerial, and that he or she does not have any powers to solely determine, accept, reject, or otherwise adjudicate disputes over electors. So it's like, basically, if you're the vice president, you don't have power. You're just there for ceremonial purposes. It's like when the late Queen Elizabeth and now King Charles opened Parliament. They don't actually have any power over Parliament. They don't control the parties in Parliament. They basically are there ceremoniously opening Parliament, and that's their role. That's it. That's the only job they have. All the actual decision making and the legislation happens between all the MPs and the Prime Minister. And I'm sorry, not the MPs, the representatives in there. I'm not quite sure what the UK calls them, but basically, I think they're MPs. I think they are. If you know, please let me know. I mean, I guess I could Google it, but I'll Google it later. To find out what they're called. So it's basically just purely ceremonial, so they don't have any power. And the same thing applies to the vice president here. The vice president cannot say, yep, I'm throwing this out. Nope. They're only there for the ceremony. And then it says higher objection threshold. So I think this one is pretty important too, because we saw that we had certain members of Congress. I don't remember the exact number of Congress, and it was mainly the House of Representatives. I think there was a couple of senators who also contesting these votes and expecting them to be thrown out. And now there's a threshold for the objections. It basically specifies you have to have this many people on board. And it raises the threshold to lodge an objection to electors to at least 1/5 of the duly chosen and sworn members of both the House of Representatives and the Senate. So 1/5 of Congress, so 1/5 in the House and 1/5 in the Senate have to agree in order to raise the objection. And let me just do my little math here and do some calculation. And I will tell you exactly how many people in the House have to agree. 225. So mathing is not one of my strong suits. So you have to have almost 100 members, a little over 100 actually, to contest in the House. And I would like to think there are not that many people who would want to go against the will of the people and stand in the way of democracy in either chamber, but you never know. In fact, historians and political scientists always say, if you want to see the results of an insurrection, or of like if there would be a successful coup or insurrection, you have to look at the previous insurrection, and because people learn, right? So I'm hoping that we have enough people who would not try to object unless there was like some real serious reason. And then it says this change would reduce the likelihood of frivolous objections by ensuring that objections are broadly supported. Currently, only a single member of both chambers is needed to object to an elector or slate of electors. So like in the last election where we had the objections, we saw Senator Josh Hawley. He I think, did Ted Cruz also do it? I don't know. I know Josh Hawley for sure launched an objection. And then you had like Marjorie Taylor Greene, who launched an objection. And so it was obviously not something broadly supported because most members of Congress were willing to certify the electoral count. But it felt kind of like a stunt when they did it. And so now that they have to get more people on board when you want to object, I think that really does. Like you have to have a compelling reason to get that many people on board with objecting to the electoral votes. And then there's protection of each state's popular vote. So it strikes a provision in an archaic 1845 law. Ooh, I didn't know about this one. Now I'm going to have to go Google. I'm going to have to go to the Googles. That could be used by state legislatures to override the popular vote in their states by declaring a failed election, a term that is not defined in law. So I guess what this is saying, and I'm going to have to go look up this 1845 law just to satisfy my own curiosity. It is no longer applicable because this reform fixes that loophole in the law. But basically, if you didn't like how your state voted for a popular vote, so let's say you're a Democratic governor and everybody goes for the Republican candidate, you can't just say, oh, we had a failed election, got to do this again, to overrule those votes. Or if you're a Republican in a state that goes for a Democrat, for president, you can't just say, nope, failed election. So we are not submitting this person. I'm just going to submit who I want. So yeah, it basically clarifies that because the term failed election was not defined anywhere in our law. So it was not codified into U.S. law, which is interesting. That is very interesting. So instead, this legislation specifies that a state could move its presidential election day, which otherwise would remain the second Tuesday immediately following the first Monday in November. Sorry, let me try that again. So which would otherwise would remain the Tuesday immediately following the first Monday in November every 4 years, only if necessitated by extraordinary and catastrophic events. I said second Tuesday because it's just a force of habit at this point. It is not the second Tuesday. It is the Tuesday immediately following the first Monday. So basically, that's interesting. The legislation specifies that a state could move its presidential election day only if necessitated by extraordinary and catastrophic events. So you can't just say we're changing the date of our federal elections. You literally have to have like a major catastrophe. Like if you were in a state that had maybe a hurricane or a tornado that destroyed most of the state, that would be catastrophic because obviously voter turnout would be very low. So that would necessitate possibly moving your election dates, but that would be your justification of that. So that is very interesting. Huh. That is so interesting, and I'm going to make this bigger. Sometimes technology does not agree with me, and we'll just go with that. So you're probably going, okay, we went into the history, we went into what the thing is, and what does it mean for the future? Well, hopefully, this has done enough to close the loopholes in the current laws, especially around the Electoral Count Act, because remember, we are still a representative democracy in this country, so we have an electoral college, and it does not abolish the electoral college. Due to technology, there are lots of calls to abolish the electoral college, but we have not made that move yet. We still are a representative democracy. We still use an electoral college. And so hopefully we won't see a lot of the behaviors that we saw in the 2020 election now that these specific things have been addressed, because it's like when your landlord gives you an agreement. And I always say landlord agreements are written for the previous tenant, right? So the landlord may start off with a very flexible, and then as they get more experience and they have more different types of tenants, they might start including provisions. Like, for example, I once had a lease that specified I had to keep my apartment clean and open windows. To like air out the apartment. And I was thinking to myself, like, that's just common sense. Like, who doesn't clean? But then again, if you think of it from that angle where like those agreements are written for people who've come before you, then they probably did have like a tenant who did not do those things. So it's in your agreement now. And again, like a lot of this legislation, a lot of laws, a lot of reform bills are the result of we had a situation we didn't think we would have. So we never really looked at this. So we didn't anticipate this. So we didn't write legislation before it happened. So we're writing this in response. So it's very like reactive to these kinds of things, especially when you're talking about reforms. Reforms are always reactive. Usually they're reacting to something, whether it's current legislation, current policy, whatever's happening in the United States. And so hopefully, because this was written in response to what happened and what we're finding out happened, and how the former vaguely written laws were exploited. This is aiming to close those loopholes. So hopefully this does that. We really won't know until somebody tries to use this, basically. Like most of policymaking, and this is the thing that I think a lot of people don't understand. It's really hard to anticipate what you will need in the future, and respond to that, right? So policymaking by its nature is very reactive, and the only way to know if something is effective is to let it take its course and see what happens. And then based off of what happened, you can tweak it and change it, or, make changes, tweak it, whatever you need to do. It's very incremental in its approach. There is never going to be this big, huge, comprehensive, like this fixes everything, kind of legislation or policy that gets put into place, because you don't know what you don't know. And that's just the truth of the matter. I mean, the founding fathers could not have anticipated our world today, which is why the Constitution was a framework. If you look at laws from, like, for example, this law from the 1880s, there was no way they could anticipate how elections could be run today. First of all, we have more people, and we have faster technology, and we have more instantaneous communication. So we're not waiting for like a horse and buggy to get here, or like the Wells Fargo wagon to Stagecoach. Sorry. Music Man just went through my head. That was my ADD brain at work there. So you don't have like the Stagecoach that you're waiting for. You don't have slower mail service that you're waiting for. Like, these things can be submitted electronically. It can happen very instantaneously. So there was no like real thing. And then also, I think in some cases, like for those kinds of antiquated laws, just based off of, discourse of the time period, you might think the society would respect the law as it was written in your time, because we are all products of our time period. So it is hard to judge somebody based off of current standards, or to judge what the future generations might do, because we just don't know. Cultures shift. Values shift, morals shift. They are all things that shift with time and growing understanding, and just however we change, that's how we change. So I don't think that they could have anticipated that there would be a need. I mean, for God's sakes, they didn't see women's suffrage or the Civil Rights Acts of 1965 and women's suffrage in, the early 1900s. And that was like 20 years later. So, I think it's really important to just remember that policy making is a very reactive thing. Usually you're writing a policy, or you're introducing a policy, or you're passing legislation for policies in response to something else. And that the best gauge of effectiveness is just time. And you have to be very retrospective about it and tweak it as it comes, because we cannot anticipate the perfect scenario. So I'm hoping that this is the piece of legislation we needed to close those loopholes and we never see something like that again, and that it's very clear. But ultimately, only time can tell. And that's the truth. So anyway, I hope you found that topic very informative, if not interesting. I love history, so anytime that I get to include history into policymaking makes me very, very happy girl. I mean, I'm one of those people that read the Federalist Papers for fun. But that's it for today's show. If you found it useful, if you liked it, go ahead and do all the likey thingies on your podcast of choice. If you're watching this on YouTube, click that like or subscribe or that bell thing to be notified in the next one. And I will see you next time.